Does anyone who wants to go into a lecture, you can go on into the lecture now.
And prosecutors. Like that. I'll get it back.
So, good morning, everyone. My name is Tony Natale, and how I came up with this presentation was having gone through the college, the National College of Students, and then teaching there, and teaching particularly at this seminar for several years. I began to think of, well, what is it that we're really doing here? And for myself, if I can visualize something, come up with an image of something or a model of something, I have found that it helps me sometimes if I get stuck. And what I mean by an image or a model is that if we were putting together a lawnmower, it's real helpful to know what a lawnmower looks like and what a lawnmower is supposed to do. Because maybe then when you look at the pieces, you can figure out why and how it should go together. In listening to what everyone said, because nothing what I'm going to talk about here is very original. I'm just putting together things that I've learned from David Lewis, Jim Shello, Posner and Dodd, Gene Iredale, and countless other people, Terry McCarthy. And what I want to talk about is the real event of a trial. A trial is a real historical event. It has a life of its own. The cross-examination are real. They are real events. And we hope that if we create that real event in such a way that it's going to be persuasive, and it's going to be persuasive to the jury. Before we can talk about the three images or models I want to talk about, I've got to make sure we're all on the same sort of ground floor. We have the same foundation. The theory of your case is that combination of fact and law, which in a common sense, in an emotional way, leads the jury, for purposes of this aspect of it, leads the jury, is the operative word, leads the jury to conclude that the accused has been wrongfully charged. Combination of fact and law, which in a common sense and emotional way leads the jury. Why do you think I'm saying leads the jury?
Well, we don't want to follow people, first of all.
Right. What else?
And I think there's a whole notion of control that you're talking about when you walk into a courtroom, and it becomes your courtroom as soon as you go in there. Told to comply about that. It's not the judge's courtroom, it's not the prosecutor's courtroom, it's certainly not the witness's courtroom. And so, if it's your courtroom, then you're leading the jury.
Well, okay, but are you going to tell the jury what to think?
Although in effect leading the jury almost literally, because they're theoretically wrong, but in reality they're thinking that
First of all, someone needs to lead because they don't know the facts of the case. But more importantly, you can talk at someone all you want, tell them what to believe. Are they going to believe it? No. If someone comes up with a conclusion or a belief on their own, is it stronger? Is it? No, of course it is. Plus, given who we are, lawyers, they know we're there to try to impose our will, trick them, force stuff on them. If we go in there and allow them to hear information and lead them through information, which makes them conclude something, right? Two things occur. One, we've upset their stereotype. And two, they have now become invested in this real event. But they've been invested in such a way that the conclusion that the person has been wrongfully accused is theirs. And so now, which attorney is saying, do what I say? Don't follow your own thoughts. The prosecutor, not you. So if we start off that that's the theory of the case, cross-examination. Cross-examination is where you are using the prosecution's witnesses through facts will lead the jury to conclude or have certain feelings, images, or beliefs which are necessary if they are going to believe your client's been wrongfully accused. You're using someone else's witness to get out facts and impressions which the jury is going to adopt. And by adopting them, that will cause them to conclude that this person should not have been charged the way they're charged. Now, if we accept that, then we view that a cross-examination is a controlled communication of a focused message. A control, that means you know what you're doing. It's the exact opposite of voir dire. Voir dire is the exact opposite. A good voir dire is the exact opposite of a good cross. Cross-examination is control. Communications. In order to have communications, you have to have two things at least. What are they? To have meaningful communication.
Attention.
What?
The attention to who you're talking to.
Well, you've got to have someone delivering the message and someone receiving it. Without receiving the message, is there communication? Right? So you can have all the control you want, but if you don't have communication, you've got what? You've got zip up, nothing. It's a controlled communication of a focused message. When I say focused, of a particular point, of a particular matter. So, that's another one of our ground level things. So now we know what it is, right? We know that the focused communication is control. There are three aspects, not only to an effective or persuasive cross-examination, but everything we do. There's a technical aspect. What do you think I mean by technique? Technical stuff. Leading questions. All the stuff that McCarthy talked about. Things that David talked about. There's techniques, just like in tennis. If you're going to do a backhand, there is a technical way of doing it. In the Olympics, technical merit, right? Techniques. Good techniques make things go smooth, makes it go easy. There's substance. The subject matter. Is the subject matter something that is meaningful? Is something the jury can relate to? Is something that's going to further your theory of the case? And then emotion. What are the emotions? What is the psychological dynamics that's going on in the courtroom as it relates to this matter, to this cross-examination? If all three of these are working in harmony with one another, you will be persuasive. When you have a cross-examination that's going bad, or when you're preparing one, and I want to talk more about preparation, think about if you're stuck. Am I stuck because of a technical reason? Am I stuck because this isn't an area that makes sense? Or is it stuck because I've gotten angry at a witness when there was no reason to? And think about what I'm saying. In the last 2 days, you saw situations where it was how the question was phrased that got someone in trouble, or it was the area that you were talking about was just a tar pit, or maybe you seemed to get angry when there really wasn't any need. This is the sort of stuff that comes up. So now, we're now going to start thinking about these three areas. Let's talk about substance. On top here, I have a timeline. Up here is real time. When I say real time, I mean how the event really occurred. And let's say where I have bad stuff. In real life, the bad stuff took 3 hours. Right? We're just picking 3 hours. Now, in the prosecution of that case, how much of the time allotted to the prosecution does she want to spend on the bad stuff? How much? As much as she can. Right? It doesn't take place. The trial doesn't take place in real time. The prosecutor wants to expand and make the whole thing here the bad stuff. Right? As a defense, what do we want to do? We don't want it to happen in real time either, do we? We want to do what? We want to contract the time. Right? Now, how and why do we want to contract the time? Because we're saying that the only way a meaningful decision can be made of this case is if it is analyzed in the way that we want. Now, you come into the room and you see me punch someone. You have an impression, right? If you came into the room a little earlier and you saw, say it was Andrew that I punched, and you came into the room a little early, and Andrew said, "I'm going to cut your nose, you scumbag," and he reached into his pocket and you saw the same punch, would you have the same impression as when you first came into the room? Would you? Of course not. Now what happens is you came into the room and you heard what Andrew said and did. You saw that. You saw the very same punch. And then Tina came in and said, "Cut. When we film it, do it exactly that way." Would you get a third impression? Right. Obviously. Why? Did the punch change in any of the scenarios? Right? But what did change? And we were able to do what with the punch? Okay. What I just did there is something you need to think about doing in voir dire, that we need to show how it's going to illustrate in our cross-examination. And in preparing of your cross-examination, there are going to be what Paz and Donna talk about your facts beyond dispute, right? Your job is to identify and to present to the jury facts which come before, impressions which come before, in the middle, during and after the facts in dispute, which do what? Put it into context. The prosecutor will want to deal with the punch, right? And talk about all the damage of the punch. But starting in your voir dire, and then most importantly, follow through in your cross-examination, you are going to cross-examine on what? What was said by Andrew first, and what was said by Tina second, right? And you will say that a punch is meaningless. And the problem we had with Stephanie Powers, if two people are in copulation, and that's all you see, do you know if it's a rape or if it's consensual? Do you? What do you need to know? What occurred before and after? Now, if you voir dired on that and you set up on that, now you have them ready, but now you've got to deliver on your cross-examination. So your cross-examination has got to be facts, substance, and impressions that are going to allow you to communicate the context of the bad act, because they are going to be there. Now, some decisions you're going to have to make. This is all the witnesses in a case. These are the facts that you need for your closing, right? Not every witness can give you every fact, right? So you've got to make a decision. Which facts, which impressions do I get from which witness? What do we use to making that determination? What's the first rule that we have? What do you think? I'll tell you what it is. Which one can I get it from easiest? Who will give it to me the cleanest and in the easiest way? Why? Because once you've got it, you've got it. Second, is there one of these people that I can get it, and if I get it from them, it will have more impact? And then third, do I want to risk asking everyone who can give me fact D, or do I not? Why are you nodding your head?
Well, because with that many people, you're going to get probably 4 or 5 versions of fact D.
And therefore, what may happen?
You're losing credibility of that fact.
or you may dilute its effectiveness. Okay? So, after you have organized all the data and all the facts and you've put it together, you need to either, in your mind, or somehow chart it out to where you know where you're going to get it. For example, you have a lead detective in most cases, and you have the first police officer on the scene. Who has got the most investment in the case emotionally, generally? The lead detective. So if you try to use the lead detective to educate on everything that could have been done, should have been done, right? He or she is going to be the most reluctant to give that to you, right? But the first police officer on the scene, generally speaking, may be younger, wanting to move up the ranks, and wanting to invest in his future or her future. So they are going to say, I did everything I was supposed to. I did this, I did this, I did this. And say, but officer, you didn't do these things. Say, no, it isn't my job because I was just the first officer. But if I were the detective, I would have done this, because that all makes sense. So now you are using that witness to get out to the jury what should have been done, what could have been done, because it's easy. That witness isn't going to be prepared to fight you on that while the lead detective would. Okay? Now, there's the substance of it. The next thing we have is the technical stuff. We've talked a lot about that. And most of the other lectures dealt with techniques. Closed-ended questions, one new fact per question, nodding your head, looping. All of these things are techniques that you need to learn to practice. And I'm going to talk about practicing. There are things that we need to do that we don't do. Most lawyers, if lawyers were to be actors, they'd say, just give me the script and I'll show up on opening night. Right? We need to practice. And how do we practice? Well, we don't have batting cages. But when we're preparing our cross-examination, we need to say, I want to ask this question, not I want to get into this area. What is the question? And then you have to, with a friend or someone, say, what are all the possible answers that anyone could give? If you don't have a way of dealing with every one of those answers, then maybe you should think that that's not a good question. And think about rephrasing. This is how you practice. So there's certain techniques that you need to learn how to do. The other thing is there's really an emotional aspect of it. How many people had problems doing the cross-examination step? How many people had problems because it was just uncomfortable and you personally haven't worked through it? The emotional aspect of a case will prevent you. If you haven't dealt with it, it will prevent you from being effective. Things to do in preparing for these cross. What about the psychological reenactment, the stream of consciousness reenactment? If your story is true, what are the sort of things that people would have had to be thinking and feeling in order to make it happen that way? If they didn't think and feel that way, then maybe it didn't happen that way. Same thing with the prosecution. Physical reenactment of it. Really go do all that physical stuff in advance. How does it work? How does it move? Because it may not be as easy to do or as accurately done as what they were for. And then the third way is a legal reenactment. When did events become significant or lose their significance? So if you go through all of this before you do your cross-examination, you're probably going to be in a situation where saying, well, that's the way I think. But I don't know how the jury's going to think. So now what you have to do is talk to other people. Because one of the things that every juror has is a story. They have a way that they think things happen. If someone says to you, someone got stabbed in the parking lot, every one of you automatically has a picture and an image in your mind as to how it occurred. Right? And you will fill in the gaps and they will fill in the gaps. So a lot of times you can cross-examine people not on what they actually did or saw or heard, but what the jury would expect them to have done, would have expected them to have felt, would have expected them to realize, fear, and believe. And the fact that the witness doesn't do that only puts them at odds with the jury. We're going to examples of that. But let's go to the first model. This is the first image. Let's assume that you're here and the jury's here. And you have a ball. You have balls. And the balls are points. The points you need to make in your closing argument. The more balls the jury catches, the greater likelihood you're going to win the game. All right? Now, between you and the jury, the easiest way would be to just throw them to the jury, right? Or walk them and give them to the jury, right? If this was a game. But you can't. You know why? Because there is a block. And the block is called the judge of the rules of evidence that prevents you from just going and putting them in the jury. Right? So you can't do that. So you've got to throw the ball against a wall. And the wall is actually the witness. And then it has to bounce off the witness and land at the jury box. That's the game. All right? Everyone understand that's the game. If that was the game, what are some of the things that you would do to get ready for this game? Anybody? What would you do?
Kind of the angles of the law of difference.
Figure out the angles, right? What are some of the variables? Okay. One, how fast you throw the ball. How hard you throw the ball. The size of the ball. Whether the ball is soft, whether the ball is hard. Where on the wall it hits. You may throw it here, but it would bounce into the audience, which means you may make a point that the audience likes, but if the jury does it help you know?
Whether or not the jury has good hands.
Whether or not the jury has good hands. So you have to know who has the hands. What now? Let's translate this into our trial. What do you mean by good hands?
Well, you've had it for a year with the jury. Once you pick your jury, you have a sense of what their capacities are by asking the questions. You understand what they're going to understand and what they're not going to understand.
Okay, so you have an idea of maybe how to package it. Or you may realize that there was an economist that you have on your jury. So there's some part of your cross-examination that you want that point to hit that person. Right? You want people to have good hands. What else would you want to have? What else would you want to do?
You want to know whether or not the angle that you're throwing the ball off of is going to change after you throw the ball. It's going to depend upon what the witness is, who the witness is. If it's your witness on direct, you're going to expect that witness to hold the wall firm and steady while you throw the ball. If it's not your witness, you're going to expect the witness to try to do this. We're going to change the angle.
So then what you have to do is you got to be sharp as to where the wall is to make sure you're doing what? That every ball you throw is doing what? Is hitting the wall in a place that what will happen? It'll get to the jury, right? You ever see what he's saying? He's saying, well, there's a person there with the wall who may be moving it. So what does that mean? You've got to be maybe a little ahead of that person, or you've got to know how to do what? To throw the ball so that what? What happens? No matter what the person does with the wall, what happens with the ball? It bounces off and still gets to the jury. Right? Now, if this is a game, what would you do then to get ready for a trial? What would you do? It's a real easy question.
Practice.
And what would you practice doing? You practice by throwing balls. You practice by throwing different types of balls, different speeds of balls, different sizes, different shapes. Right? Do you do that now when you're preparing for a trial? No, we don't. Okay. If you think of this image or model in preparing now for your cross-examination, we now have a checklist of things we've got to be thinking about. This question, this ball, is it too hard? Is it too soft? Is it too big? I can't lift it. I can't throw it, right? That's your getting greedy question when you ask that home run question, the conclusion question, right? Right? You know what I'm saying? It's too heavy. Well, even if you're strong enough to heave it, and it hits the wall, right? It may crush the wall, or it won't bounce off. If it doesn't bounce off, does the jury get it? No. Or if it does bounce off, they don't understand and appreciate it, right? If the ball is too small, right? That's hard to catch, right? If they're coming in too fast, right? If they're coming in too slow. So now I want you to begin to use your imagination, looking at this model and saying, what are all the different things that we're really manipulating in a cross-examination? Because isn't this what cross-examination is? Isn't this the game we're playing? Isn't it? Really, this is a discussion. This isn't just a one-way thing here. So that's one image to think about. And if you think about that image in terms of technical aspects, substantive aspects, and emotional aspects, this is one way of dealing with structuring and putting together your cross. Second image. Anyone here familiar with art? Pointillist? Well, I'll tell you what they are. There was a school of impressionistic painting where what they did is they put tiny dots. They put dots. And they painted by doing dots. And if you were up close, all you see is color and dots. But as you back up, you see the picture. How many people have looked at a newspaper? Have you ever seen a photograph in a newspaper? Have you ever looked at it under a microscope or a magnifying glass? Or get real close up? Does the picture become clearer or less clear the closer you get? What?
It's just what you're saying. You have a photograph, your dots also, your shades, black and white.
But if you're too close to it, if you are too close to it, even though it's all there, you can't see it, can you? Right? It is only when you back up with perspective that what happens? The image becomes clear. Right? Now, what about TVs? It's the same way. A TV screen is just a series of dots. Think about it. Cross-examination is you placing dots. Cross-examination is you placing the dots. Closing argument is you pulling the jury back and giving the perspective to see the whole picture. How many people were told, save that for argument in their cross? Well, this is what we're illustrating. So let's think about it. If you're making little dots, your cross-examination is your little dots. But you understand that when they're being made, everyone is too close and it may not seem clear. What do you got to make sure? And what else? You got to make sure there's enough dots there so when you get back, what happens? There is the whole picture. Now, keeping in mind substance, technique, and emotion, and everything else that we learned. This is the model. The model is we're going to put little dots. Let's use, what are some of the things then, in preparing our cross, in delivering our cross, we can manipulate using this dot idea? What are some of the things? What happens in a painting? What are some of the things they manipulate? Color. Color. Now what's the equivalent of color with words? Tone. Do you say committed a crime or committed a robbery? The impact of your words. Your word choice is your colors. Right? Now you can, so now there's the color of the dot. What The size of the dots, right? What about the number of dots? The sequence and the pacing of the dots. Right? Now, let's have a little exercise here. I will never say that I am cold. But I will say yes to any fact you make up which would lead someone else to believe that I was cold on a particular day. Okay? Do everyone understand the rules? And all you do is come up with a fact, that's the question to me. And if it's a fact, I will say yes. And your job is to convince someone that I was cold at a particular time. Okay? I'm going to point to people, come up with a question.
You ever felt the temperature like you were at your
No. That's not a fact, is it? That's not a fact. That's an impression. Yes. Yes.
You didn't have a hat on.
Yes.
We're wearing gloves.
Yes.
You can see your breath.
Yes.
Fingers.
Yes.
It's snowing.
Yes.
You didn't have a shirt on.
Yes.
Snot coming out of your nose is real.
Yes.
You went back home and got a heavier jacket.
Mhm. Does that help you convince me I was cold?
You or other
Once I
people.
put the coat on, I'd be warm. Do you see how all of these little, we can take this out, do you see how all those little facts put together? Anyone is going to believe I was cold, even though if you say, well, so you were cold. No, I wasn't cold. You understand what I'm getting at? By putting the little dots in an order and painting the picture. Painting the picture by using the dots. Now, does that mean that in every spot of every cross-examination of every witness, the jury is going to know why you are asking those points? No. Some of it they aren't going to know. And the witness isn't going to know, and that's the way you want it. Why? Why do you want it that way? Because, what? Good. No, go ahead.
They'll try to obstruct you.
They'll try to obstruct you. When you're going to tie it all in is when? In your summation. Now, if you're going to be painting the picture, and there's many characters and many aspects of it, you've got to deal with each image, right? Just like when I showed you the chart, you have got to deal with each witness. So each witness is another part of the larger picture. So what I want you to think about is this image of pointing, putting the dots, placing dots, the arrangement of dots. And now think of, well, wait a minute, I'm now putting together my cross, I have to execute. What is the best way to make the point? Should I make this one big? Should I make it little? Should I make it colorful? Should I make it bland? Do I want to put this point next to this point? See what I'm getting at? So this is another image that you can sort of think of. Again, this, what I'm talking about here may not be for everyone. I think this is helpful for people who sort of have sort of more like a visual way of analyzing things or like to sort of play with things and think of it. Now, the pace with which you throw the paint on there, you got to be careful. Because if it's too fast and too hard, what may happen? It splatters, and one color runs over onto the other, and you get a color that you really don't like, right? So we've got to be careful. So when we talk about the pacing and sequence, the analogy is, well, I got to make sure I put that dot right where I want it and how I want it. So I have to have my emotions in check, my emotions under control, understand how they are going to affect the substance and how they're going to, how I'm going to use my technique to keep that all under control. Now, when I That's not what I'm talking about. I'm talking the control to understand, to go with the flow, to make it flow. Too often we view control as us putting, a hammer grip on. We're talking about laying it out there so you're controlling what they see, how they see it. You're not controlling what they think. The third image that I want to talk about is the one that you've often heard, which is you have a chapter, a subject, and you're pulling the witness down this corridor, right? You've heard this in all before. And there's avenues of potential escape. Now, this is something that I learned from Jim Shelley, is that when you're closing off these avenues of escape, you're really not closing off every possible answer. You're not. Because you cannot do that. The human imagination is too wonderful to do that. What you are closing off are the plausible explanations. The explanations that would cause the jury to say, well, that makes sense. In fact, there may be a real benefit, and Jim, this is something I learned from him, that the significance of impeaching someone by a prior inconsistent statement doesn't really come from, they said this on one day and this on another day. It's how do they react to that situation? How do they react to the live event of being confronted with that? And what do they say? When I show you the tape of my cousin Vinny, you're going to see an example of how different people respond when they are placed in that situation of having to deal with mutually inconsistent things or statements which were made by them. It illustrates their character. And if it's done right, the character trait they will show is one which helps your theory of the case, either because it shows some bias or some evil intent, or it shows inaccuracy, a mistake. Now, you take the person down and you get them to a point and you stop. And then you use the transition, as Terry said, it's very wrong. Now I want to talk to you about this. And you take them down this way. For example, let's say if we wanted to start off with someone's prior record, we take them down there. And then we go to their use of AKAs, aliases, take them down. Then we take them through the sequence of how they were visited by certain lawyers, and we take them down. And then we take it down the chronology of their life as it relates to a deal or no deal, and we end up here. So we have now down to this point, and while we're taking the witness, we're taking the jury. Remember those like suspense movies where someone is always going down what? A corridor. Very rarely do they have someone in an open field, right? Right? They're going down a corridor. And it's a corridor which has doors, doesn't it? Because it heightens suspense. And they manipulate sight, sound, light, pace of how fast they move. Here are ways that you can do that in your cross-examination. For example, how do you get someone? You did this, and this is really interesting. This is really funny stuff, actually, because it doesn't. It's real simple. You make a list of you did this, you did this, you did this, you did this. You didn't do this, 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 or this. An example of it. You went to your apartment. You walked in the door. You went into the room. You didn't scream. You didn't kick. You see how you go through all the things that happened and all the things which never occurred. creative. I'm bored with that. You say, you didn't do this, you didn't do this, you didn't do this, and when you go through the whole list of didn't do, what you did was, and then you go through your list of did. Now, you don't want to bore the jury, so now you're getting really pretty creative here. You say, here's what I'm going to do. You did this. You didn't do that. You did this. You didn't do that. All right? Now, there's more than 3 witnesses in the case, so now you've changed it around and say, well, you didn't do this. No, you did this. You didn't do this. You did that. That's how you're getting them down there. And you can use and manipulate it any way you want, depending on what you think is going to be the impact. It's what you did, what you didn't do. Remember, there is always what did happen. There is always something that could have occurred that didn't. And you're just pointing out that it didn't occur. We do it all the time with the police officer. You didn't record it. You didn't write it down. You didn't ask for someone else to hear it. You didn't ask for someone to repeat it. You just put the cuffs on and you walked away. So think about using that as a technique of getting down the corridor. Another thing I want you to start to think about is this. When we're going down the corridor in a science fiction movie or in any sort of suspense movie, they always are doing a number of things with us. And Hitchcock was the greatest at doing this, giving you a fact, and then there's an action. There's a thought, there's a feeling, there's a reaction. So let's think about it. A fact question. Here's a fact question. You went into the door. All right? An action question. You opened the door. Thought question. You didn't know what was on the other side. You were apprehensive. You still went in. You see how I used 4 questions, but on different areas. The fact, the action, the thought, the feeling, and the reaction. Now, you can't necessarily use this in all cases, but if you think about that, what you are doing is walking the jury along. Now, you opened the door, you didn't know what was behind it. You were concerned, right? Now, let's assume that the person had heard gunshots before they opened the door. You say, you were concerned when you opened the door. What is the witness going to say? What are all the possible answers they could give you? Yes, I was concerned. No, I wasn't. Okay? What do you think most people on the jury are going to think? They would have been concerned, or they should have been concerned. So if the person says, no, I wasn't concerned, the jury's going to say, wait a minute. So they've got to have a good reason for why they weren't. You see what I'm getting at? When Terry talks about plausibility and verisimilitude, you have got to do that psychological, consciousness, the physical reenactment, the psychological reenactment, so you can come up with questions which say the fact, the action, the thought, the feeling, and then to walk them through. Now, this isn't going to work in every case for every witness. This is just something that in the appropriate case, you want to figure out, is this a technique that I can use to walk them down to this point? Now, let's look at the videotape of my cousin Vinny and see if he does some of this stuff. Now, obviously, there's a lot of humor. identify them.
Mr. Dick, when you viewed the defendants walking from their car into the sack of sun, what angle was your point of view?
They was kind of walking toward me when they hit the stone.
And when they left, what angle was your point of view?
They was kind of walking away from me.
So would you say you got a better shot of them going in and not so much coming out?
You could say that.
I did say that. Would you say that?
Yeah.
Is it possible the two youths,
Okay, let's stop. Look at what he just did. Common sense. If someone's walking towards you, you get a better way of looking at them than if they're going away. Right? So he set that up. Now watch how we use it. I'm going to fast forward through the youth part because I don't want to spend too much time, although it is kind of fun.
two specific items off of the shelves? Is it possible the two defendants entered the store, picked 22 specific items off of the shelves, had the clerk take money, make change, then leave? Then, two different men drive up in a civil... Don't shake your hand, I'm not done yet. Wait till you hear the whole thing, so you understand this. Two different men drive up in a civil-looking car, go in, shoot the clerk, rob him, and then leave?
No, they didn't have enough time.
Well, how much time was they in the store?
5 minutes.
5 minutes? Are you sure? Did you look at your watch? Oh, I'm sorry. You testified earlier that the boys went into the store and you had just begun to make breakfast. You were just ready to eat. You heard a gunshot. That's right. So obviously it takes you 5 minutes to make breakfast.
Let me tell you something about before this scene. You see that what this guy did was he went to everyone and interviewed them. So he interviewed the guy at his house, and he knew that the guy cooked breakfast, and he knew what the guy cooked. Now let's see what we can find out.
Do you remember what you had? Eggs and grits. How are things too? How do you cook your grits? You like them regular, creamy, or al dente?
Just regular, I guess.
Regular. Instant grits?
I'm self-respecting Southern uses instant grits. I take pride in my grits.
So, Mr. Dixon, how could it take you 5 minutes to cook your grits when it takes the entire grit-eating world 20 minutes?
This is what Jim talks about, putting someone in a situation where they got to come up with something.
I don't know. I'm a fast cook, I guess.
I'm sorry, I was all the way over here. I couldn't hear you. Did you say you're a fast cook? That's it? Are we to believe that boiling water soaks into a grit faster in your kitchen than on any place on the face of the earth?
I don't know.
Well, perhaps the laws of physics cease to exist on your stove. Were these magic grits? I mean, did you buy them from the same guy who sold Jack beef for beef?
Objection, Your Honor. Objection sustained.
Are you sure about that 5 minutes?
No other question.
Are you sure about that 5 minutes?
I don't know. I think you made your point.
Okay. Now, if we take out the humor, and obviously the technique has problems with it, right? But look at what he did. He tied into the jury. They know about grits. They know about how long it takes. Now, what did they make this person look like? This person was allowed to make himself look like the character that he really is. Right? We're going to watch with the next cross-examination how he gets another witness, but yet you're left with a different impression of the person than you are with this one. That's not working out.
Why you been fake? I got no more use for this guy.
Yeah.
How
Well, right back.
Hey, Abel. Hey, Mr. Frank, what are these pictures of?
My house and stuff.
House and stuff. And what is this brown stuff on the windows?
Dirt.
Dirt?
What's the sequence of
What
the dots
is this
placed?
rusty, dusty, dirty-looking thing over your window?
Screen.
A screen. It's a screen. And what are these really big things right in the middle of your view, from the window of your kitchen to the stack of suds? What do we call these big things?
Trees.
Trees, that's right. Don't be afraid to shout them right out when you know. Now, what are these thousands of little things that are on trees? Leaves.
Is he walking the jury in him through the life
And these bushes
situation?
in between the trees. Bushes. So, Mr. Gray, you could positively identify the defendants for a moment of 2 seconds, looking through this dirty window, this crud-covered screen, these trees with all these leaves on them, and I don't know how many bushes.
Like 5.
Don't forget this one and this one.
7 bushes.
7 bushes. So, what do you think? Is it possible you just saw 2 guys in a green convertible and not necessarily these 2 particular guys?
I suppose.
I'll finish with this guy.
Now, this follow, these sum up questions on the end could kill you. So let's take them out for technical reasons. Was this point made without
When you saw the defendants, were you wearing your glasses? Yes, I was. Over here, dear.
Now remember, he interviewed all these people
Glasses
first.
on for us, please. Whoa, unbelievable wearing glasses. This was thick. Have they always been that thick? Oh no, they got thicker over the years. So as your eyes have gotten more and more out of whack, as you've gotten older, how many different levels of thickness have you gone through? Oh, I don't know. Over 60 years, maybe 10 times. Maybe you're ready for a thicker step. Oh no, I think they're okay. Maybe we should make sure. Let's check out. Now, how far were the defendants from you when you saw them entering the sack of sun? Now, 100 feet, 100 feet. Would you hold this, please? Thank you. Sorry, excuse me. Sorry. Okay, this is 50 feet. That's half the distance. How many fingers am I holding up?
Let the record show that counselors holding up 2 fingers.
Your Honor, please, huh?
Oh. Sorry.
Now, Mrs. Riley, and only Mrs. Riley.
Should have done that
How
first.
many fingers am I holding up now? Oh. What do you think now, dear? Think should get thicker glass? Okay. Hey, where did you read about all that squash? What?
promoted the structure of forensic studies for the Federal Bureau of Investigation.
How long have you been in that position?
18 years.
Ron, may we approach the bench, please?
You wish.
I object to this witness being called at this time. We've been given no prior notice he testified, no discovery of any tests he's conducted or reports he's prepared, and as the court is aware, the defendant is entitled to advance notice of any witness who will testify, particularly those who will give scientific evidence so that we can properly prepare for cross-examination, as well as to give the defense an opportunity to have the witness reports reviewed by a defense expert who might then be in a position to contradict the veracity of his conclusions.
That is a lucid, intelligent, well thought out objection.
Thank you.
Overruled.
Now, Mr. Wilson, these photos of tires belonging to the defendant's car, and these are photos of the tire marks left by the assailant's car as it fled the convenience store. Now, are you familiar with these?
Yes, I am.
Could you elaborate, please?
We compared the tire marks outside the convenience store with the rear tires of the defendant's car. They're the same model and size tire. Visually model SGV, size 75 R14 and 12.
They're the same size and model. Anything else?
Yes, indeed. The car, leaving the convenience store, spun its rear tires dramatically and left residue of rubber on the asphalt. Now, I took a sample of that rubber and analyzed it. I also took a sample of the rubber from the rear tires of the defendant's Buick and analyzed that too.
What kind of equipment did you use to find this out?
I used the Hewlett Packard 5710A dual column gas chromatograph with flame analyzation detectors.
That's taking turkey chops.
Only on the floor model.
Now, Mr. Wilson, what was the result of your analysis?
The chemical composition between the two samples was found to be identical.
No further questions, Your Honor.
In terms of these three elements,
Mr. Wilson?
watch this cross-examination.
Court will take a 60-minute recess for lunch.
Your Honor, I respectfully request a full day of continuance to all of these. Is it possible two separate cars could be driving a Michelin model XGV 75? What's the most popular size?
75 R14.
The same size as on the defendant's car.
A two baby green 1964 Buick Skyhawk convertible.
Excuse me. What I'm asking is if the most popular size of the most popular tire is on the defendant's car.
Well, yeah.
Yes. Thank you. No further questions.
Okay. What about that last cross? What do you feel about the last cross? Sam?
Well, he made the point, but you knew that, he didn't really have it.
His emotion, he didn't deliver it with the same sort of emotion. There was things that he could have made, and of course, the rubber would be the same in all of the tires that were made from the same factory. He could have taken that and done more with it, but what made that cross, if you will, less effective? It wasn't the substance of what he was getting into. And we know the technique, he wasn't doing what the technique we talked about here. But it was the emotion that he didn't bring to it. We gotta end, but one of the things I hope that we tried to show is that in a situation, in these cross-examinations that he did, they were short, they were effective, but yet I think that if you look at the images I'm talking about, the throwing the balls that the jury would catch, talking about the grits, that was something they could get, they could understand. He's walking the guy down the corridor, putting the jury with all of the stuff in front of them, something they could understand. Look at the emotional tone he left the woman with in her glasses versus the tone he left the grit guy with. Right? Why? Because what did she say when she was confronted with just the fact that she needs one more level of lens when she's had a history of having it? What is her reaction? Yeah, you're right, yes, so. What was the reaction of the guy, their primary witness to the identification, when he was confronted with the absurdity of his position? I'm a fast cook. You get a double whammy there, because he came up with something that shows a character trait. A real event was created there with a true character, something the person couldn't prepare from, came forward. And that is, this is an individual who doesn't deal with recognizing the truth and isn't able to say the truth and admit they're wrong. So therefore, this is someone you have to be very skeptical of. I hope that what I gave was helpful and that it helps you down the road. Thank you.